AI framework. He will speak about trademark and AI. Please, Professor Arcidiacono.
Thank you for having me. Thanks to Emanuele Arezzo. Thank you all for the patience. I'll try to be brief enough. Okay, my presentation, I'll try to address some, of course, not all the problems deriving from the interrelation between trademark law and AI, but I've chosen these three ones. First of all, I would like to highlight the problems that arise when online platforms and in particular operators of online marketplaces use trademarks where consumer purchases are suggested, recommended, or directly made by AI systems. And the second one is related to the first one, the issue of liability of online platforms, and of course, in particular, the operators of online marketplaces that arise from such use. And the third one, which may appear departed from the previous two ones, is there a way to interpret trademark law in a way that promotes, fosters a digital environment which is conducive of free competition for the benefit of consumers? This is another quite puzzling topic. Okay, we can move on. But first of all, some authors have hypothesized a complete substitution of AI in making purchase decisions for consumers. Is this a sound point of reference to start reflections on trademark law and AI? We can move on. Of course, if we hypothesize a maximum efficiency of AI in identifying the consumption preferences of each individual, that would mean that, okay, we can get rid of trademarks because they are not anymore a tool for simplifying consumers' purchasing choices. And trademarks are no more a way to reduce cost for searching in the search for satisfactory products. This is what Greenberg in particular has said. Yeah. And so the death of trademarks in this scenario. Other authors have referred to forms of automated purchasing that use Internet of Things and blockchain, and have spoken in this case of the removal of the human from trademark law, and in particular Roy Marsouf. And so in this scenario, they advocate a complete rethinking, a complete reinterpretation of trademark law. Of course, starting from the point where human is left out of the purchase decision. Okay, move on. So we could ask ourselves, is the human completely out of the picture? Is the consumer in flesh and blood out of this scenario? Okay, of course, the cases where automatic purchase ordering is in place are rare, at least today, and probably in the today and in the future, Veblen goods like luxury goods or products with a high unit value will remain an activity left to consumers in flesh and blood. But even if we hypothesize the scenario where automated systems purchase goods on behalf of consumers, remains the inevitable possibility, so even in the shipping then shopping model, that the consumer faced with unsatisfactory products may change her mind. And so, for example, request the return or indicate for the future a different preference. So this inevitable possibility rules out, in my opinion, a complete replacement of the human being in online purchasing decisions. And so in this sense, in other words, even in this scenario, even in the shipping then shopping scenario, the consumer retains her sovereignty, at least as a reference of last resort. So, are the trademark functions still relevant? So, the human is in the retains a center stage, even in this quite rare hypothesis, but are trademark functions still relevant? Of course, the short answer is yes, because of course, if we want to preserve the ultimate sovereignty of the individual consumer, it's necessary that even in the case of automated ordering, be possible for the consumer to easily identify the commercial origin of the automatically ordered goods. And this, of course, means that the trademark function of origin must continue to be protected. And, of course, if we protect the distinctive function of trademarks, the trademarks can build a reputation brand image that, according to EU trademark law, deserves protection. And so, in taking into account the EU law, the different functions performed by trademarks is confirmed. They maintain their center stage, and so trademark law retains its relevance and usefulness, even in the face of possible dominance of automated purchasing systems in the future. Yeah. What about the average consumer? The average consumer is the point of reference to ascertain whether there is a likelihood of confusion, for example. But in this case, when an AI that acts as a shopping assistant suggests the purchase of goods that infringe trademark rights of others, the traditional average consumer concept can be confirmed. But what if there is an automatic ordering system in place? We have to go, of course, beyond the model of the average consumer. And so we could talk about the AI average consumer. A model, a typical model of an agent constructed on the basis of the characteristics that can be expected from the proper functioning of an AI, taking into account the technological development reached at the time of the alleged infringement. And of course, for these purposes, within these limits, we could also envisage a judicial review of the algorithms and factors taken into account by AIs which assist or replace the consumer in her choices of purchase. And this judicial review, of course, has to go to delve deep into the functioning of these systems, but this is not a problem from the trade secrets point of view, because We have in place sufficient protection of trade secrets when judicial authority looks into those algorithms, so we could easily admit that. And so, at the end of the day, it seems inevitable, at least for certain purposes, to construct a model that lacks the peculiarities, the cognitive and perceptual limitations of the average consumer, and at the same time has its own deficiencies, of course taking into account the technology available at the time of the alleged infringement, where likelihood of confusion can be said to exist. What are from the point of view of liability? This model, this AI average consumer model, can, on the one hand, in the context of targeted recommendation services, makes possible to identify the limit beyond which the service provider cannot be held liable for trademark infringements that have not been filtered out due to defects in perception that cannot be eliminated by appropriate systems, of course, as long as they cannot be eliminated by appropriate systems. And on the other hand, in the case of automated purchases made by the service provider on behalf of the customer, the model of AI chosen appears to be functional for the identification of innocent infringing behavior, of course, to exclude the service provider's liability for damages. So in this case, I would say if we assume that the service of targeted recommendations or automated purchases falls within the scope of the Directive on Information Services and the Digital Services Act, and of course assuming that even in this case the service provider would still be subject to injunctive measures, of course, etc., etc., for the purposes of applying the system of safe harbor established by EU law, to ensure that the service provider limits itself to a neutral provision of the service by means of purely technical and automatic processing, and does not play a role capable of conferring on it any knowledge or control of such data, we can go to the other slides. We can say that the use of trademarks by the said systems is neutral from this point of view, because in these cases the AI makes a use of such data that does not interfere in any way with the packaging of the website or of the message addressed to the public. In this case, the targeted suggestions would simply bring to the consumer's attention advertisements on the basis, and this is the point, of objective analysis. So in this case, it's a neutral provision of service. We can move on. And of course, in this case, the pursuit of ever greater objectivity, in the case of systems for targeted suggestion, automated purchasing using form of AI, the system is able to increasingly refine its predictive decision-making capabilities by way of machine learning and deep learning in ways that are autonomously developed by the AI itself. And this brings us to the pro-competitive function of AI systems on online marketplaces. Because the thing is that the success with consumers of certain online marketplaces, which make extensive use of machine learning and deep learning for their targeted and micro-targeted advertising, indicates, in fact, their ability to efficiently capture consumer preferences, and thus, offering satisfactory products. And in addition, the algorithm often suggests products with trademarks that are far from being known, and in fact, they are alternatives to branded products. And so, if we look at this way of functioning of the online marketplaces that use AI systems, we could easily say it's a way to increase market competition to the benefit of consumers. Because, of course, consumers in this case purchase products which are equivalent, but that are cheaper than the branded products. But if we look at the court cases across Europe, this pro-competitive function of online marketplaces is not regarded. One indicative and illustrative case is the Ortlieb case. It's a German case which gave rise to a decision by BGH in 2019. The case was quite illustrative, as I said. Amazon, which operates an online marketplace, made use of another's trademarks as an advertiser. Amazon bought from an online search engine operator, Google, a keyword corresponding to a trademark. In this case, the trademark was Ortlieb. So that when the user of the search engine entered the trademark, a link to a page of Amazon's website appeared among the sponsored results. But once the user clicked on the link and landed on the Amazon's page, the algorithm presented the trademark proprietor's products together with those of other competing companies, which is a completely normal scenario if we are used to the functioning of Amazon's website, to be honest. But what the BGH said is that such use gives rise to a likelihood of confusion for the average internet user, because the average internet users may be led to believe that the competing goods are actually commercially related to the trademark owner, in this case, Ortlieb. This brings us to the last problem that I would like to bring up here. So, this example, as this case shows us, poses us a real important question. Is a high level of protection for trademark owners also beneficial for consumers in the online shopping environment? Well, to be honest, the thing is that in the online environment, in my opinion, a high level of protection against the risk of confusion does not necessarily mean a high level of protection of the interest of all consumers. On the contrary, the protection of the unsuspecting consumer comes at the expense of the freedom of choice of all the other consumers. All the other consumers who are normally attentive and circumspect. So we should better focus on the concept of the average internet user to allow more competition on the online shopping environment. So if we want a vibrant shopping experience, if we want an online shopping where machine learning and deep learning deliver on their promises of more and better consumer choices, the average consumer must be interpreted in such a way that has sufficient knowledge of the rules of operation of the tool he or she is using. In this sense, can be also considered circumspect and not clueless. So the referent agent model in this case should know the basic mechanism of the functioning of the algorithms of online marketplaces that, as I have already said, usually present together with the products of the brands sought by the consumer also other products that are relevant for the consumer's interest on the basis of the data processed by the machine learning or deep learning system. And if I'm not wrong, this approach is confirmed by the EU legislation, in particular by Articles 26 and 27 of the Digital Services Act, because these articles say that the consumer poses an obligation on the online platforms to inform consumers about the main parameters used by the operator of the online marketplace, to recommend or promote different purchase alternatives. And so in this sense, the consumer is a subject that, by law, is undoubtedly capable of understanding the basic working of the algorithms. And so, in the case that, as we all know, the algorithms are designed to offer commercial alternatives, the knowledge of such parameters are fully integrated into the knowledge of the average internet user and consumer. And this is what I have, and this is about the likelihood of confusion. What about the protection of the other ancillary functions that are equally protected by trademark law in the EU, in EU law? We can draw some indication from the judgment of the ECJ in the Interflora case. And in particular, the very fact that online marketplaces offer commercial alternatives suggests that, in principle, the other ancillary functions are not affected. In the end, if we look at what happens, trademark owners can always invest in advertising their products in order to achieve a better ranking among the sponsored results in the online marketplace. So, if we look at the Interflora case, there is no problem there. So the advertising investment function of trademarks cannot be said to be impaired either. Also, the concept that I'm advocating here, in my opinion, is consistent with other EU fundamental principles. So not only with our competition model, but also with, it is more in line with constitutional protection of freedom of commercial information for consumers. And last but not least, with freedom of enterprise. Thank you for the attention.